How's it going, everybody? This is going to be a quick video update on the Miller v. Becerra case. But real quick before we jump into this video, if you think that California's Assault Weapons Control Act violates the Second Amendment, go ahead and hit that like button and subscribe. I also want to give a shout out to some of the main sponsors of the channel, the first being Thorson Custom. Thorson Custom provides so much more than California compliant features for AR style rifles. They also are very active in court cases and funding cases that ultimately seek to abolish those laws that make their parts relevant in the state of California. So Thorson's an amazing company, and if you're interested in taking a look at them, I'll put a link to them down in the details section. I also want to give a shout out to Got Your Six. For just $2.99 a month, you get access to a lot of amazing things on their app. This includes up-to-date local, state, and national legislative information, and they have neat features like the Initiate Freedom button, so if your Second Amendment rights are ever violated through something like a red flag law, you can click this button, and what is an Amber Alert for gun owners goes out to members of your group. So if you're interested in taking a look at this app, I'll put a link to them as well down in the details section. So Miller v. Becerra, this is a very high-profile case in the state of California, and it seeks to actually challenge and get rid of California's assault weapons ban by targeting the Assault Weapons Control Act. Now, I'm not going to talk comprehensively about what Miller v. Becerra entails. I have tons of videos on my channel that discuss that, and you can actually click this tab right here, and it'll take you to a playlist of all the videos I have on Miller v. Becerra. So last time we discussed Miller v. Becerra, we were talking about how the trial date was set for January, as well as that there was some supplemental briefings that were actually hitting the docket, and we talked about those supplemental briefings and what they entailed and what it revealed about what happened at the evidentiary hearing on the motion for preliminary injunction. And since that last video, we got some additional information that hit the docket, and primarily being the pretrial briefs by both parties, both by Firearms Policy Coalition and the other plaintiffs, as well as defendants in the state of California. So first and foremost, the pretrial conference for Miller v. Becerra is set for December 16th, 2020. I believe it's at 10 a.m. Before Judge Benitez. Of course, Judge Benitez is the one that's going to be hearing all these issues. So one of the first things I want to address is, what is a pretrial hearing or a pretrial conference? A lot of you aren't in the practice of law, so you're not familiar with what exactly this all entails. You know that there is an actual hearing in January, but now you're hearing that there is a pretrial conference set for December. So what does that entail? What all is that? So the whole purpose of a pretrial hearing is to kind of smooth over the actual hearing. And so in this case, to smooth over the hearing that's going to be had in January, as well as there are briefs that are submitted by both parties in anticipation of that pretrial conference to address some of the main things that are going on in the case. And it's really to help the judge wrap his head or her head around what is actually going to be at issue in the hearing. And it is also a mechanism for the parties to get together to potentially agree to a settlement. If a settlement it's like at issue, here there's going to be no sort of settlement or agreement, of course, because the state of California is not going to let this go. That's not even going to be an option here. But for some cases, a settlement is potentially there at a pretrial hearing, as well as at a pretrial hearing or conference, the judge can set some constraints for going forward with the actual trial. And one thing that also happens a lot at the pretrial hearings is that the judge will simplify the issues that are actually going to be at issue in the actual trial. So what could happen at the pretrial is Judge Benitez could look at all the pretrial briefs submitted by our side as well as the defendant's side and condense those issues that are actually going to be present during the full-blown trial in January. And one thing that's kind of neat about looking at pretrial briefs is you can really get a good understanding about what each side is going to argue during the actual full-blown trial. So here, by looking at the pretrial briefs, you can see what a lot of our side is going to argue, as well as a lot of what the state is going to argue. Now, a lot of this stuff isn't super nuanced. It's what you would expect from each side to argue. But there were some really neat gems that were in some of these pretrial briefs, and some things actually made me chuckle when you looked at the pretrial brief by the state of California. And there's one specific thing that was put out by Firearms Policy Coalition on their Instagram. And when I actually looked at the pretrial brief, it really made me laugh. And so if you want to find this, you go to the defendant's pretrial brief. It's on page 5, and it's on subsection C, where the state of California is addressing pistol grips, thumbhole stocks, and barrel shrouds. And it's their whole discussion about why those things make these types of rifles very dangerous. They're unusual weapons. They're not in common use. If you look at page 5, there's their discussion about pistol grips. And what it states is that a pistol grip can enable a shooter to maintain aim and even fire while reloading a detachable magazine. So here, the state of California is citing their expert as a valid reason for why pistol grips are dangerous, why rifles with these types of features are dangerous. And their experts said that pistol grips are dangerous because they allow you to control the weapon and keep firing while you're reloading. And if you're scratching your head about that one, I think we all are scratching our head about that. Because essentially what the expert is saying is that you can continue to fire while you're empty and reloading because of a pistol grip. And that's really what we're up against here in the state of California. I think that really clarifies the extent of knowledge that a lot of these so-called experts have on these cases, as well as the extent of knowledge that the state of California has on firearms. When it comes to actual firearm knowledge and the function of firearms, or what all these things actually are, the state of California doesn't have knowledge, and they really don't care, to be frank. Ultimately, the state's whole goal is to just attack the Second Amendment, get rid of firearms. They don't want to know about these items. They don't want to know the extent of how these things operate. They just accept certain arguments wholesale. They just adopt the assault weapons language. They just adopt that these various features are evil, that black rifles are evil, and they just adopt gun control laws wholesale. And that permeates beyond just the state of California. I mean, here you have an expert who feels like he's an expert enough to be an expert in a very important case in the state of California, talking about our fundamental rights. And he's making a statement about how this type of feature is evil, it's unusual and dangerous, but then he talks about it in a way that makes it very clear he has no knowledge about firearms. Now, when you look at the other arguments that were presented by the state of California in the pretrial brief, it's nothing that you wouldn't expect. They kind of go through the list of the features that are addressed in the Assault Weapons Control Act, and they categorically go through and talk about how threaded barrels are dangerous, pistol grips are dangerous, collapsible stocks are dangerous, flash hiders are dangerous, and they give their various rationales about why these items make these rifles so much more dangerous and unusual than other types of firearms. And then they go on to talk about how the civilian AR-15 is just the same as an M16. They're not distinguishable. And then, of course, they conclude their pretrial brief by talking about how intermediate scrutiny should be applied to the Assault Weapons Control Act. And if you're not familiar with what intermediate scrutiny is, it's just a lower level of scrutiny when you're looking at whether a law burdens the Second Amendment or does not. Strict scrutiny being the highest standard, which makes it really hard to validate any type of governmental infringement. Intermediate scrutiny kind of being what it sounds like, that medium level. And then there are lower bars of scrutiny, but that don't apply to the Second Amendment. But of course, the state always wants the lower bar to jump over, which would be intermediate scrutiny. So that's why they always argue for that. Whereas our side always argues for strict scrutiny because, of course, these laws do strike at the core of the Second Amendment, are an infringement of our fundamental rights, and therefore strict scrutiny should be applied. So that's what you see by both sides all the time. You have one side argue for strict scrutiny, you have the other side argue for intermediate scrutiny. And as a basis for why intermediate scrutiny should be applied and the major public interest that the state has in regulating these types of firearms, the state of California is citing mass shootings. That's been the whole rationale, allegedly, behind the Assault Weapons Control Act, was to limit mass shootings. So the state is citing that as a major public interest, and that is why this law is valid and would pass intermediate scrutiny. And of course, the FPC side, the plaintiff side, is arguing that strict scrutiny should be applied, but even under intermediate scrutiny, this law would still fail because the alleged public interest of mass shooting, it hasn't been clearly shown that regulating these types of rifles or these types of features or these firearms would reduce alleged mass shootings, and the data doesn't really support that state's interest at all. So that's just a quick rundown of the pretrial briefs, what we're looking forward to as far as the pretrial, which again is set for December 16th. Now, it's not going to be live streamed. I'm sure FPC and the other plaintiffs, San Diego County gun owners, will be doing updates probably for the pretrial brief. I will also be trying to give you guys updates for the pretrial hearing as well. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and you like to support the channel, one of the best ways you can do that is like, comment, subscribe, and make sure you hit that notification bell because that helps the channel analytics, helps us spread the word about the Second Amendment, and also helps spread the word about things like this that are going on in the state of California. So as always, thanks you guys for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.